ina kaishe ku jamata. Keke derim undim. Enyara mi bawo ni. Good day, everyone. Imagine a governor who receives 2 billion naira meant for public funds into his personal accounts. He thinks of ideas to convert this money into his personal use. He reasons with himself, what can I do? He invests this money into businesses. He can also, as well as buy properties under people's name. And he can go as far as converting this money into cryptocurrencies, such as Bitcoin, Ethereum, and what have you. And you keep wondering how the governor has been able to put such amount of money into his personal use without leaving any trace to the public. So this process is called money laundering. It is the process of converting dirty money into clean money without leaving any trace. So let's take the Article 3, Paragraph 1 of the UNN Convention 1988 in Vienna. This convention simply states that money laundering is the process of converting or transferring property by way of criminal activity without leaving any trace to its illicit origin. Also, in the case of Dawodu versus FRN 2018, the Supreme Court simply put it plainly that money laundering is the washing of illegitimate money to make it appear legitimate. You see, this plague of money laundering is a scourge ravaging not just in Nigeria but across the world, and there is a need to talk about it.
One thing that makes money laundering unique is that it cannot stand alone. It is what lawyers call a derivative offense, meaning it depends entirely on the existence of a prior crime. Without corruption, fraud, drug trafficking, or some other unlawful activities generating proceeds, there is nothing to launder. The stolen money is the raw material. Laundering is just what happens next. This is not just a theoretical point. In Ago-Iwoye versus FRN, the Supreme Court was clear. Prosecution must first establish that the funds in question were connected to unlawful activities. Until that link is proven, no laundering charge can succeed. The predicate offense is the foundation. Everything else is built on it.
So how does money laundering actually work in practice? It moves through 3 stages, and understanding them helps explain why it is so hard to catch. So the first stage is placement. The criminal gets the dirty money into the financial system, cash deposits, payment through businesses, currency exchanges. The goal is just to get the money in. Then secondly, layering. This is where the real concealment happens. The money moves through multiple accounts, multiple companies, multiple countries. Each transfer makes it harder to trace back to the original source. Then the last stage is integration. The money comes back out looking clean. It reappears as investment returns, rental incomes, or proceeds from asset sales. At this point, it is nearly indistinguishable from legitimate wealth. The crime has been completed at this point.
Why is money laundering a serious criminal offense? Money laundering is a serious crime because it allows criminals to enjoy the benefit of illegal activities. Money obtained through corruption, fraud, drug trafficking, or other crimes cannot be used freely without raising suspicion. Money laundering hides the true source of that money and makes it appear legitimate. It is also dangerous because it is often involved more than one person. In Onabanjo versus Federal Republic of Nigeria, the Court of Appeal stated that to prove conspiracy to commit money laundering, there must be an agreement between persons to commit the offense and participation in carrying it out. This shows that money laundering is often an organized crime involving networks of people. For this reason, money laundering is treated as a separate and serious criminal offense under the law.
The impact of money laundering in society. The damage money laundering causes go far beyond any single case. The Financial Action Task Force has documented how it allows criminals to infiltrate financial institutions, corrupt public officials, and quietly take control of legitimate businesses. In Nigeria, we have seen it used to compromise elections, hollow out government agencies, and channel public wealth into private hands. The Bego case brought this into sharp focus, Mohammed Dede Bello and the former Minister of National Planning were charged with receiving 450 million naira in cash allegedly traced to a former Minister of Petroleum Resources in the run-up to the 2015 election and distributing it to individuals without going through any financial institution. The Supreme Court struck out the charge on jurisdictional grounds, but the fact tells us something important. Money laundering is not just an economic crime. In Nigeria, it has been a weapon used against democracy itself.
The Nigerian legal response is anchored by the Money Laundering Prevention and Prohibition Act 2022. The primary legislation is currently governing that aspect of law. It criminalizes the money laundering activities and imposing compliance obligations on individual and institution. And it is mainly enforced by the Economic and Financial Crime Commission with oversight support from the Central Bank of Nigeria. The Act also aligns Nigeria with its international function under the FATF standard, which is the global framework for combating money laundering and terrorist financing. This is not just a domestic law, it is Nigeria's commitment to the international financial community.
Know your customer. One of the Act's most practical tools is the Know Your Customer requirement, also known as KYC. Every financial institution must identify and verify their customers using BVN, NIN, or a valid government-issued ID and maintain transaction records for prescribed periods. The reason is simple. Anonymity is the launderer's greatest asset. If you can open an account without being identified, then you can move money without being traced. KYC closes that door. No verified identity, no account. No account, no clean paper trail.
The Act also compels financial institutions to report any cash transaction of 5 million naira or above for an individual or 10 million naira for a corporate body must be reported to the Nigeria Financial Intelligence Unit. Beyond those tiers, institutions must also file suspicious transaction reports whenever a transaction raises red flag, regardless of the amount. This is important. Financial institutions are not passive under this law. They are active participants in detention. Failure to report is itself a criminal offense. The system is designed so that silence is not an option.
The Act goes further by prohibiting the very infrastructure that launderers depend on: anonymous accounts, numbered accounts without verified identities, fictitious accounts, and shell banks are all prohibited. Financial institutions cannot maintain correspondent bank relationship that enable shell bank operations either. The logic here is structural. You do not just catch launderers after the fact. You design the financial system so that the tools they need do not exist. Prevention is built into the architecture of the law itself.
Attract a minimum of 14 years imprisonment. Two Supreme Court cases explain this concept. In Ago-Iwoye vs. Federal Republic of Nigeria 2017 and Ude-Jones Ude-Ogun vs. Federal Republic of Nigeria 2019. The cases are a warning. Trials in money laundering are the same as criminal proceedings. It is not enough to prove guilt. The process of establishing the guilt must itself be lawful.
Nigeria loses hundreds of billions every year. This issue of money laundering is the engine that keeps this cycle going. It is what converts public wealth into private comforts. The agencies exist, the laws exist, the court exists. What Nigeria needs now is a kind of way to combat these three forces together, whereby they become working forces. And if they are not compromised, I think Nigeria will be a better country that will be free from this crime of money laundering. Thank you for watching.